Hello, I'm Don Hubin from National Parents Organization. What I want to talk about today are some of the myths about equal shared parenting that are just not true. Let me begin by saying just a little bit about National Parents Organization. We are the nation's largest and most effective equal shared parenting organization. We have chapters now in 27 states, and we work with state-based organizations in other states to promote equal shared parenting. I describe NPO as being child-focused and research-based, and I mean by that we ground our advocacy for shared parenting on the best research available about child well-being. And I'm going to be sharing some of the summaries of some of the best research on child well-being with you today. But first, why is it important to debunk myths in general, but in particular about shared parenting? Well, the best answer I have to that is from Mark Twain, who said, "It ain't what you don't know that gets you in trouble. It's what you know for sure that just ain't so." And there are a lot of things that people think they know for sure about shared parenting that are just wrong. I like to say that there are many things that stand to reason and wind up falling to experience. So in 2022, National Parents Organization collaborated with the International Council on Shared Parenting to create some educational materials to debunk common myths about equal shared parenting. We produced two one-page handouts that briefly state what the myths are, provide the facts about the myths, and most importantly, provide citations to the research that establishes that these are in fact myths about shared parenting. So let's start right off with one criticism that is often made about shared parenting. In particular, it's made often by judges and attorneys when we advocate for there being a presumption of equal shared parenting. The myth is this: shared parenting is a one-size-fits-all arrangement. So what people say is, look, every case is different. You can't use a cookie cutter. And so you have to just have no presumptions whatsoever. Let the court in every case do whatever it thinks is best, and don't impose this constraint on the court that it apply a cookie cutter approach. I call this the cookie cutter criticism for obvious reasons. And the first thing I want to say about it is it's a dishonest criticism if it's made in defense of current practices, because most courts rely upon a parenting time schedule as a default schedule. In Ohio, where I live, that's required by statute. So every county court handling parenting issues has to have a local rule that determines what the default schedule of parenting will be. And we've done studies of this 2018 and 2019. We're finishing, I'm sorry, 2018 and 2020, and we're finishing up a further study right now. And what we found is that the vast majority of Ohio courts relied on schedules that are absolute cookie cutters. They specify particular times. So, for example, alternate weekdays from 6 p.m. Friday to 6 p.m. Sunday, and Wednesdays from 6 p.m. to 8 p.m., something like that. Now, if that's not a cookie cutter, I don't know what is. But what about this criticism of presumptions of equal shared parenting? Are they really a one-size-fits-all approach, which means that they won't fit most people at all? Well, the answer is that, of course, every case is different, and there are differences in the way the parents relate to the kids. There are differences in how close they live together. There are differences in what their work schedules are. And so you do have to be flexible in establishing a schedule. But shared parenting is the presumption of equal shared parenting is an incredibly flexible approach to separated parenting. There are many different equal shared parenting schedules to fit the needs of different families. Now, research has shown that different schedules are appropriate for children of different ages. So infants and toddlers need more frequent time with each of the parents in order to form strong bonds with both parents. That doesn't mean that one of the parents needs to be sidelined in the children's lives. It just means that they can't go as long time with each parent before they see the other parent. So they need more frequent exchanges there in order for them to establish the parent-child bond that's so important to child well-being. And of course, parents' work schedules might require different parenting schedules. Does a presumption of equal shared parenting make it difficult to adjust the schedules to handle these differences? Well, the answer is no. So opponents of shared parenting seem not to understand how flexible equal shared parenting schedules are. Perhaps, I will recommend tongue-in-cheek, they should augment their natural intelligence with some artificial intelligence. Because just this morning, I decided to ask ChatGPT and Google Bard, the two artificial intelligence programs that have been receiving a lot of attention recently, how you would devise an equal parenting time schedule. And they came up with answers. And of course, there are many more than the ones they came up with. But here's what ChatGPT said. I asked, what are some different schedules for equal shared parenting? Well, one, of course, is alternating weeks. And that may be an appropriate schedule for older children. Another one is a 2-3-2 schedule. So the children are with one parent for 2 days, the other parent for 2 days, and then the first parent for 3 days, and then the next week it flips. So they're with the second parent for 2 days, the third parent for the first parent for 2 days, and then the other parent for 3 days. Or there's a 3-4-4-3 schedule as well that works. Google's artificial intelligence program, Bard, came up with even another answer. So in addition to the alternating weeks and the 2-3-2 and 3-4-4-3 schedule, it picked out a schedule that's very commonly used. It's 2-2-5-5 schedule. And what that does really is to alternate weekends and then alternate weeks with the children. And that means that the children don't go an entire week without seeing one of the parents. Different schedules may be appropriate for children of different ages, and there are a lot of ways to work out individual schedules. The requirement that you start by trying to keep both parents equally involved in the children's life is nothing like a cookie cutter. Well, here's another myth we often hear, that parenting roles should remain the same after separation or divorce, and presuming equal parenting time wouldn't do that. So very often in an intact marriage, you'll find that the parents have exercised a kind of specialization, a kind of, one parent will do more of the external work that is necessary to support the family financially, and the other parent may be doing more of the work of housework and raising the children. And that can be an appropriate thing for parents to do. There's certainly nothing wrong with that. But when parents divorce, parenting roles almost always have to change in those cases. So very frequently, a parent who hasn't worked very much outside the household will need to start working outside the household more than that parent has in the past. And a parent that hasn't been taking on the primary responsibility for child rearing and so forth will have to take that on. That's true whatever the parenting time schedule is, whether it's every other weekend and one evening a week, or whether it's one of the 50-50 schedules that will provide children with equal access to both their parents. So if a parent has never cooked dinner before, they're going to be on their own and they'll be cooking dinner, whether it's 2 nights a week on the weekend when the children are with them, or whether it's week on and week off. The roles change, and there's nothing wrong with that. In fact, it can be a very good thing for children to see parents taking on different responsibilities, show that both parents are capable of the child rearing responsibilities, and both are capable of working outside the home to raise money for the family. We also often hear that presumptions of shared parenting have been tried somewhere and were found to be unsuccessful. Now, we've tried to track down the source of these myths, and the fact is we cannot find any jurisdiction that has had a presumption of equal shared parenting and then reversed that because of unsuccessful outcomes. We've sometimes seen California cited as an example of that, but in fact, that turned out to be completely false. California never had a presumption of equal physical custody or equal parenting time. And there was a bill passed at one point that clarified that that wasn't a presumption of the law, but it was not a change in the law. And public polling demonstrates that presumptions of shared parenting are incredibly popular with the public, and research has also shown that equal shared parenting presumptions are favored by divorced professionals. So we don't expect any of the jurisdictions where shared parenting has been created as a presumption to turn those presumptions back. For example, in Kentucky, we did polling after the enactment of the 2018 presumption of equal shared parenting. And when I say we did, I don't mean NPO called up people and said, We're a shared parenting organization. What do you think of shared parenting? We hired a respected independent polling company to poll Kentuckians to find out what their attitudes were towards this shared parenting law. And when we asked them if they supported the equal shared parenting law, 58% said that they supported that. Only 10% opposed it, 32% were not sure. And I suspect some of that was because they weren't sure exactly what it meant to say equal shared parenting presumption. Because when we ask them whether they agree or disagree with the law, that it is in the child's best interest to have as much time as possible with both fit parents in instances of divorce, 83% agreed and only 7% disagreed. So it's extraordinarily popular with ordinary citizens in Kentucky, which is one of the states that's had shared parenting for the longest time now. And Kentucky Family Court Judge Micah Pence said this: I can tell you that all of us as judges were hesitant about 50-50. I can honestly say I love it. It truly is a fair starting place. Going in biased to one side or the other and making it a zero-sum game just isn't fair to the kids. So there's support among judges. Now, that's just anecdotal. That's one judge from Kentucky. But Arizona has had fairly strong equal shared parenting laws since 2013. And in 2018, they did a comprehensive study of divorce professionals' attitudes about the shared parenting law in Kentucky. And the law was, this is a quote, evaluated positively overall and in terms of children's best interest by the majority of conciliation court staff, the majority of judges, the majority of mental health professionals, and by the plurality of attorneys. That is, more attorneys evaluated it favorably than unfavorably. So we don't expect shared parenting laws to be reversed, given the popularity they have with the general public and the popularity they have with divorce professionals once they're in place and they have had experience with it. Sometimes critics of shared parenting argue that shared parenting arrangements are unstable, that it might start out with the parents doing shared parenting, but eventually it sort of devolves into a sole custody arrangement, except it's still called shared parenting. Now, that myth found some support in a very old study that was done in the 1980s in California. It did suggest that shared parenting arrangements tended to drift over time to sole mother custody arrangements. And recent research, though, has demonstrated that the living arrangements of children with shared placement were at least as stable as those of children with sole mother placement. Now, you might say, what's changed? Was the study in 1980 just a bad study? Well, maybe it was a bad study. Maybe it was a small study. Maybe it wasn't an unrepresentative sample, but it was done in the 1980s. And probably the data came from the 1970s. And there has been enormous change in the way parents raise their children since the 1970s and the 1980s. So it turns out that at least now the best research says that shared parenting arrangements are at least as stable as sole custody arrangements. Sometimes critics say that fathers could share in the equal custody of their children if they wanted to share more equally in the responsibility of raising children. I don't know where they get the impression that fathers don't want to share in the responsibility of raising children, but it turns out there are significant barriers to fathers being equally responsible for raising children. One is child support. Child support often limits a father's ability to set up a residence that supports equal shared physical custody. And National Parents Organization in 2022 undertook the nation's first study of our child support laws and how those laws affect shared parenting. We found that in 9 states, there's no adjustment to a child support obligor's obligation based on how much time the children are with that child support obligor. That means that if a parent never sees his or her children, they'll presumptively pay the same amount of child support as a parent who has the children with them 50% of the time. So that can be a significant barrier to someone continuing to be a parent to their children, especially at lower and moderate income levels. But there are other barriers as well. There are significant legal battles that have to be fought in those states that don't have a presumption of equal shared parenting. A scenario that divorcing fathers often hear when they are faced with a divorce and wind up going to an attorney is this. The attorney says, well, what sort of child custody arrangement do you want? And the father will say, well, I want shared parenting. I've been an involved, active father, and I want shared parenting. And the attorney will say, well, what does mom want? And the father will say, well, mom wants sole custody. And the attorney will say, well, what's wrong with mom? And dad will say, well, nothing's wrong with mom, but nothing's wrong with me either. And the attorney will then say, well, we can fight for shared parenting, but it'll cost $30,000, maybe $50,000, maybe more. And there's no guarantee that you'll get it. So at that point, there are many fathers who say, well, I can't do that to my family's finances, and they just give up. So the fact is, these significant barriers to equal shared parenting often make it the case that fathers can't fight to be equal shared parents. Another myth that people often rely on is that children will be less supported financially if they spend equal time living with fathers, because it'll decrease the amount of child support the father must pay. Remember, I said that in 9 states, there was no adjustment based on how much time the children were with the parent that's paying child support. But the other states do have an adjustment. Some of them are pretty bad. And so, but some of them are quite significant. And so it is true that when parents are sharing equally in raising their children, there is usually less money transferred from one parent to the other. But financial support for children can either be direct, that's what parents spend on their children themselves in supporting their children, or indirect, that's what one parent gives to the other parent to spend on the children. And equal shared parenting can often result in there being less indirect spending on the child, but it always results in there being much more direct spending. I would say that any parent who thinks that they're going to reduce the amount of money they spend on their children by having their children with them more time is making a serious mistake. It costs more, and children in shared parenting arrangements get the benefit of greater financial investment from their parents than those parents in sole custody arrangements. So that is just false. Sometimes people say shared parenting increases parental conflict, that you're forcing these parents to continue to work together, and that forces them to continually fight with one another. But there's no scientific support for that claim. And in fact, studies show that mothers and fathers practicing shared parenting report less conflict and more emotional support and positive feelings with their ex-spouses. Also in the category of conflict, but much more extreme, critics of shared parenting say that shared parenting increases domestic violence, or intimate partner violence. The idea is you're forcing this parent who may be the victim of domestic violence to continue to interact with his or her perpetrator. And so you're giving more opportunity for domestic violence. There's no evidence in support of that claim, and recent research has demonstrated just the opposite. Presumptions of equal shared parenting reduce the incidence of intimate partner violence and of female partner homicides. First, though, by way of background, let me quote at some length a quote from the Canadian researcher Edward Crook. In his book, The Equal Shared Parenting Presumption, he says this: winner-take-all adversarial processes and sole custody or primary residence orders are strongly associated with exacerbated or the creation of parental conflict. Hawthorne and Lennings, 2 researchers, found that limiting fathers' involvement in children's lives via sole maternal custody judgments was correlated with their reported levels of subsequent hostility towards their ex-wives. Interparental conflict decreases over time in shared custody arrangements and increases in sole custody arrangements. Fully half of first-time family violence occurs after separation within the context of the adversarial winner-take-all sole custody system. This is no surprise given the high stakes involved. When primary parent-child relationships are threatened, the risk of violence rises dramatically. When neither parent is threatened by the loss of his or her children, conflict diminishes. The culture of animosity created by the sole custody system seems tailor-made to produce the worst possible outcomes when there are two capable parents who wish to continue as primary caregivers and cannot agree on a parenting plan and are forced to disparage each other within the adversarial system in an effort to maintain their roles as parents. The point is that it is the winner-loser approach that generates the conflict in the first place in many cases, or exacerbates conflict when there is some. Now, that's sort of background theoretical comments about this. What about the research? Well, Kentucky enacted a presumption of equal shared parenting during the divorce process in 2017 and for final orders in 2018. The Kentucky Administrative Office of Courts was asked to cross-reference civil domestic and family cases with domestic violence cases. In other words, to indicate the frequency with which a divorce or family custody case is conjoined with a domestic violence case between those same two parties. Between 2017, when Kentucky passed the presumption of equal shared parenting in temporary orders during the divorce process, and 2022, the latest data that we have, the cases of civil and domestic and family cases that also involve domestic violence cases dropped by more than half, from 988 to 454. So here is a chart showing this. You can see that starting in 2010, the oldest data they have, it was dropping already. It dropped by about a third until 2017, but it dropped by more than half again between 2017 and 2020. And we also have evidence from Spain. Spain presents what researchers call a natural experiment. They didn't set up a controlled experiment, but the world presented us with a controlled experiment. Between 2009 and 2011, 5 regions in Spain passed custody reforms that increased joint physical custody, shared parenting, fourfold in just 5 years. And what researchers found was that, quote, the policy, that's joint physical custody, significantly decreased domestic violence. Survey data indicates that intimate partner violence falls by almost 50% after the policy change. And here's a chart showing those results. So they talk about the treated regions, that's scientific lingo for the regions that had equal shared parenting presumptions, and the control regions, those are the regions that didn't have it. And 2010 is when these regions started putting in their shared parenting presumptions. This blue line shows what's happened to domestic violence cases in those regions compared to the red line in the other regions. So more research needs to be done. That's always important to do it, but the research that we have not only doesn't indicate that shared parenting exacerbates intimate partner violence, it indicates that it reduces it. Sometimes, and this is also under the heading of conflict, sometimes people will say, look, shared parenting presumptions are going to increase the cost and contentiousness of custody litigation as people fight between one of themselves over whether to have shared parenting. This is also a bit of a disingenuous argument because, of course, what the current system in most states does is to set up the winner-loser arrangement that really generates conflict, as we have already seen. There's no evidence that presumptions of equal shared parenting exacerbate the conflict between the parents or make the litigation more expensive or more difficult to resolve. And there's some evidence by divorce professionals and by the natural experiment in Spain that I just talked about that it actually reduces it. So an attorney in Kentucky that practices both in northern Kentucky and in southern Ohio reported that he's finding it easier to settle Kentucky cases than Ohio cases because Kentucky has a mandatory shared parenting presumption and Ohio doesn't. Arizona provides evidence as well. So this research that I mentioned a while ago that was done in 2018, about 5 years after Arizona put in place its shared parenting presumption, concluded this: concerns are sometimes expressed that laws favoring shared parenting time might lead to increases in parental conflict, and thus it is noteworthy that the comprehensive professional perspective is that the Arizona law has a neutral impact on parental conflict and on legal conflict. And the study in Spain that I mentioned comes to an even more promising conclusion. 5 years after the equal parenting time law was passed, the share of contentious divorces, those are contested divorces in Spain, decreased by 2.76%, equivalent, they said, to an 8.6% decrease with respect to the pre-reform mean. So there's no evidence that presumptions of shared parenting increase legal conflict, and some evidence that it decreases it. Sometimes people say, look, shared parenting may work fine when the parents are getting along, they're not in conflict with one another, but it doesn't benefit children where parents are in conflict. The parents will just be fighting with one another, and that's bad. One thing the research shows us is that it's bad for children to see parents in conflict and sustained conflict with one another. It's not always bad to see parents have conflicting opinions and to resolve those in a mature, reasonable, peaceful way. That's actually very good modeling for children. But sustained conflict is harmful for children. Everyone recognizes that. So what about cases where the parents are in conflict? And notice, many courts will say this: if these parents don't agree to shared parenting on their own, then they're in conflict with one another, and they certainly can't cooperate with one another under a shared parenting plan. So the courts take the mere fact that the parents don't come to the court agreeing on a shared parenting plan as evidence that they can't cooperate under a shared parenting plan. And that turns out to be just false. That's one of the things that lots of people think is absolutely true. It turns out it ain't exactly so, to echo Mark Twain. Even when there's conflict between parents, shared custody arrangements are better for children than sole custody arrangements on all measures of behavioral, emotional, physical, and academic well-being that are related to children having better relationships with their parents and grandparents. And the quality of the parent-child relationship, and I want to add again, reiterate, the relationship with the extended family is a better predictor of children's long-term outcomes than co-parenting conflict. And we have a great deal of research supporting this. Linda Nielsen, the researcher from Wake Forest, has done a study of more than 60 studies of child well-being that show that independently of the conflict between the parents, children do better under a shared parenting arrangement than under a sole custody arrangement. Sometimes people say, oh, all this arguing for shared parenting, that's really just emphasizing parents' rights at the expense of the best interest of the child. Now, I started out by saying I describe National Parents Organization as being child-focused and research-based. So this myth bothers me quite a bit. We are a National Parents Organization, but we are devoted to promoting children's best interest. And the primary consideration supporting a presumption of shared parenting is that it benefits children. It benefits dads too. Many people don't know that divorced fathers are 10 times as likely to commit suicide as divorced mothers. They're much more likely to experience health problems. And that largely has to do with the fact that they have been cut out of the lives, or largely cut out of the lives of their children. And that is devastating to many fathers. It is better for fathers. It's better for mothers too. We now have research to show that mothers do better economically when they have shared parenting, and they feel they're doing a better job of mothering because they're not overburdened. They get a break. And anyone who's parented children know that despite all the joys of raising children, there are also trials, and there are times when a break is very welcome. So we have now more than 40 years of social science research that shows that children do best when they're raised in a shared parenting situation when the parents are living apart. That's on virtually every metric of child well-being. And it doesn't depend upon the income of the parents or the educational level of the parents or how much conflict the parents have. It's just better for children to have a full relationship with both of their parents. Now, there are people who admit all of what we've said so far in support of shared parenting, but say, well, surely shared parenting isn't appropriate for infants and toddlers. This is sort of the echo of the the tender years doctrine. There was a judge more than a century ago now that said you can't rip a child from its mother's breast during its tender years, and that came to be called the tender years doctrine. So there are people who generally think shared parenting is a good idea, but it's not appropriate for infants and toddlers. But the research refutes that. Young children develop primary attachments to more than just one person. Some people think that it's really important for infants and toddlers to have just one person that they form a strong attachment to. That's not true. It's really important for children to develop relationships to both of their parents, strong relationships to both their parents, and that happens early on with both parents being engaged in caregiving. Restricting infants and toddlers from overnights with loving parents is inconsistent with what we know about developing that meaningful parent-child relationship in the first years of life. There's no scientific support for the claim that infants and toddlers overnighting with their fathers are harmful or interferes with their attachment to the mothers. That's another thing to emphasize. Developing a strong attachment with the father by having equal parenting time with the father does not lessen children's attachment to their mothers. It doesn't weaken that. One doesn't come at the cost of the others. This is not a zero-sum situation. Sometimes people say that shared parenting undermines children's security by requiring them to shuttle between two homes. You'll often hear words about ping pong and children ping-ponging back and forth or yo-yoing back and forth. Now, as a parent who did shared parenting of his 3 kids throughout most of their minor years, I can definitely testify that there are inconveniences sometimes. Sometimes I had to run down to their mom's home to get some homework that they had forgot to bring home to their home with me. Or in the morning, I had to stop by their mom's house to pick something up that they had to take to school. There were certainly inconveniences, but those are minor. Those are just logistics problems, and they can be worked out. And the research has shown that these minor inconveniences are not harmful to children. It doesn't undermine or hinder their developing strong relationships with both parents. Overnights up to and including equal parenting time in both parents' home benefited the long-term mother-child relationship and the father-child relationship as well. And I remember on a personal note, once saying to one of my children, my older son, when he was older and gone off to college, I said, I know that the shared parenting, meant that you were going back and forth between the two. He stopped me right there. And he said, oh, Dad, that was never a problem. That was the least of it, right? What's really devastating to children is losing a full relationship with one of their parents, not these logistical problems. Sometimes people say, look, shared parenting isn't really necessary. Equal shared parenting isn't necessary because what benefits children is the quality of the parenting, not the quantity. So this focus on equal parenting time, that's misplaced. We really just need to be making sure that both parents have quality time with the children. But it turns out that's not so. Of course, the quality of parenting is vital. Maybe even it's the most important thing, but the quantity of parenting time is vital also to children's well-being. Research shows that there are benefits to children that arise because both parents are significantly involved in ordinary day-to-day parenting responsibilities, not just weekend and holiday time. And the benefits of shared parenting for children increase as the time with each parent approaches equality. So there are really 2 points here. One is this. The standard parenting time schedule that many courts still rely on, every other weekend and 1 evening a week, which was really built on a model of parenting that is antiquated now. That means that one parent isn't involved in the ordinary parenting routines, making sure the children do their homework, getting dinner ready, getting the children off to bed, getting them up in the morning and dressed and ready for school and off to school. One parent just does this weekend meal with the children and the weekends. And that's not the kind of activity that parenting consists in. And it also leads to what's sometimes been called the Disneyland dad phenomenon. Parents who have very little time with their children think, well, I'm going to make the most of this. I'm not going to beyond them about cleaning up their rooms and stuff. Well, we're gonna go to the park. We're gonna go to a sports game or something like that. It's important that both parents involved in the ordinary tasks, the mundane tasks of parenting. That's what's really beneficial to children. But beyond that, though equality of parenting time might seem like it's just something about treating the parents equally and making sure they get their share, it's actually very important to the children, because children understand sharing something equally, and it signals to the children that the parents are both equally there for them. Neither parent is sidelined. Neither parent is in a marginalized role, and perhaps it's seen as having one foot out the door. So quantity of parenting time is important, as is quality of parenting time. Sometimes opponents of shared parenting argue that shared parenting leaves children vulnerable to abuse, that it somehow exacerbates the risk of children being abused. Now, the first thing to say about this is there's absolutely no scientific evidence to support this. And shared parenting laws and the bills that NPO has supported, and indeed, all the bills I've seen, whether they're ones that NPO initiated or supported, all of them are rebuttable presumptions. And they are rebutted when there's evidence of family violence, when there's evidence of child abuse. Health and Human Services shows no increase in cases of child maltreatment in states after the enactment of equal shared parenting presumptions. And I'll show you that evidence in just a second here. National Parents Organization led the effort in Kentucky to create the nation's first explicit equal shared parenting presumptions in 2017 for temporary orders, as I mentioned, and in 2018 for final orders. NPOs compared the child maltreatment data from the U.S. Department of Health and Human Services of Kentucky and Ohio. Ohio is a neighboring state, similar in many ways to Kentucky. Ohio doesn't have a presumption of equal shared parenting. What did we find? Well, in Ohio, the incidence of child victims of child maltreatment, that's abuse and neglect, the incidence of child maltreatment between 2017 and 2021, the latest data we have available, went down by 2.5%. That might seem like something to celebrate, until you see that just south of the Ohio River, Kentucky experienced a 33.2% decline in the incidence of child victims of maltreatment, of abuse and neglect. We have evidence from within Ohio as well. In Ohio, every family court has to have a local parenting time schedule as one of its court rules. And in 2020, NPO graded the county courts on their parenting time rules. Counties that received an A or an A- had equal parenting time rules or nearly equal parenting time rules. Counties that received grades in the D range, a D+, D, or D-, had every other weekend and one evening a week schedules. The D- actually were counties that didn't even have the midweek Wednesday evening dinner with the kids time. So the D range counties had the very old-fashioned every other weekend sort of schedule. In 2022, NPO correlated the county's grades with the rates of child maltreatment as reported to the Ohio Department of Job and Family Services, which maintains records on child maltreatment county by county in Ohio. And here's what we found. The red line in this graph represents the counties that received A's in the NPO Ohio Parenting Time Report, the counties that had presumptions of equal parenting time. This is the incidence of child abuse or neglect over time in those counties from 2012 to 2020. The blue line is the state average, and the green line is the counties that received D's, either a D+, D-, or a straight D. The counties receiving a D actually had higher rates of child abuse and maltreatment than the state averages, and the counties that received A's had much lower incidence of child maltreatment. Now, more research is needed to determine why this is. It could be that By having presumptions of equal shared parenting, you reduce the litigation between parents and allow the courts to spend more time on the difficult cases and therefore to reduce child maltreatment. It may be that by having both parents fully involved in their children's lives, you have two parents, either one of which could trigger an alarm if there's child abuse present. And often, of course, the child abuse is inflicted by a third party, a new partner of one of the parents, and the other parent can be a signal for that. More research is needed to know why this is true. But the fact is that both comparing Kentucky and Ohio cases and comparing the counties in Ohio, child abuse and neglect rates went down when there is a presumption of shared parenting. Now, one of the, I think of this as sort of a last gasp arguments, myths that have been made about shared parenting is, well, yeah, we know that the children raised in shared parenting situations do better than children raised in sole custody, but that's not because of the shared parenting. Those children do better because we also know that shared parenting is more likely to be exercised by parents that have higher income, higher levels of education, have less conflict. And so those children would do better anyway. It's not the shared parenting that causes the better outcomes. It's these other factors that are correlated with shared parenting. Now, it's very difficult to perform controlled experiments in social science. It's not as if a psychologist that wants to study the effects of shared parenting can randomly assign one family to shared parenting and one family to sole custody, even though the families are very similar, so that we can get controlled experiments there. That can't be done. But we now have good evidence that it's actually equal shared parenting that helps promote these good outcomes for children. So while it's true that in the United States, the families that choose shared parenting have other characteristics that are beneficial to children, that make it more likely that children will succeed: higher income, higher levels of education, less conflict. There's now clear evidence that shared parenting itself contributes, and the evidence comes in two forms. One, from research in other countries where shared parenting is common among all socioeconomic groups. So whether the parents are in a higher income group or a lower income group, whether they have higher levels of education or not, they do shared parenting. And we find that those families that do shared parenting, their children do better regardless of the level of income or education. But just recently, just a few years ago, two researchers from the University of Arizona, Sanford Braber and Ashley Votruba, conducted an extremely sophisticated statistical analysis on the data we have about child well-being. And that analysis showed that the benefits to children cannot be explained by these other factors of higher income and higher levels of education. Finally, there are people who say, look, shared parenting is better for kids. Okay, we get you on that. But there shouldn't be any legal presumption about parenting time. This sort of harkens back to the every case is different. You can't use a cookie cutter. Just let the courts do whatever they believe is best in any given situation. Don't create a legal presumption about parenting time at all. But it turns out that it's not just the practice of shared parenting that benefits children. Children benefit from there being a legal presumption of shared parenting. Legal presumptions of shared parenting provide parents and children with assurances that their relationship will be protected. So it reduces the conflict that the parents have. It assures the children that they're not going to lose their full relationship with one of their parents. So, and furthermore, young adults who were raised by divorced parents wish that they had more equal parenting time with both of their parents. So having a legal presumption, assuring children of that, is important for their well-being as well. Now, if you're interested in more information on this, National Parents Organization and the has on its website, that's www.sharedparenting.org, the handouts that NPO and ICSP created on the myths and truths of shared parenting. And we have links to some of the best research on shared parenting there as well. And on request, I'll be happy to provide people with any of the research that I've cited in this talk. And I want to thank you for your attention.